This is January 26, 2012. The audio from yesterday's hearing didn't come out all that well, so I wanted to review my notes that I spoke from yesterday and make a quick editorial to make sure that my stance is clear. On the first Watkins allegation, number 1, Mr. Watkins notes the topic of editorials and his Medicare insurance reimbursements. He does not attach or reference any specific editorial opinion letters. I have submitted many editorials over the years, and there has been a lot of press on this particular topic by many people, including Mr. Watkins' own editorial opinions. The topic has been in the press long before any political campaign season. All I can do is look at his written allegation and his supporting attached written narrative. His story in his narrative does reference the law in the matter of Ohio Revised Code 505.60 and 505.601. One key fact Mr. Watkins fails to disclose in his allegation is that it is illegal to take an insurance reimbursement at the same time as being on a legal township insurance plan. What I do know, and I'll quote directly from ORC 505.60 in part, Section D. If any township officer or employee elects not to participate in the township's health care plan, the township may reimburse the officer or employee for each out-of-pocket premium attributable to the coverage provided for the officer or employee for insurance benefits. In fact, Mr. Watkins was on the insurance plan and was taking a reimbursement concurrently, and this was not, and it still is not, legal. Watkins' behavior was finally stopped by the county prosecutor's office opinion to the board. Mr. Watkins names the prosecutor for his opinion in his supporting narrative to this allegation number 1. It is a fact that Mr. Watkins was breaking the law. The law is not ambiguous, but Mr. Watkins' assertions of this allegation number 1 are. The legislation noted by Mr. Watkins and his naming Mary Taylor's opinion is in regard to House Bill 458. The changes to the ORC code had nothing to do with what Mr. Watkins was doing. It was an issue about insurance cafeteria plans, changes to dependent health care coverage. House Bill 458 changed nothing in the law that would make what Mr. Watkins did to be legal. Mr. Watkins notes Mary Taylor's opinion, and in fact, Mary Taylor did make a clear stance in her bulletin about what Mr. Watkins was specifically doing. I quoted this on one of my editorials Mr. Watkins describes in his allegation number 1, Bulletin 2009-003, date issued February 10, 2009, to township officials. At that time, I was a township official. From Mary Taylor, CPA, Auditor of State, subject House Bill 458 changes to dependent health care coverage. And it says, in part, specifically to this topic, a township officer or employee can only seek reimbursement under RC 505.601 if the township does not procure and offer a health insurance policy. For example, if a trustee elects to receive health care coverage offered by the township, they cannot then be reimbursed for additional coverage such as Medicare premiums. Fact is, on allegation number 1, Mr. Watkins' reimbursement was not legal. On this Watkins allegation number 2 of posting online video claiming he was accused of not following proper bidding procedures, Mr. Watkins' supporting information referenced a specific YouTube video with an exact URL location. I carefully typed the supporting reference into the browser to see what he was talking about. The video is of a May 26, 2009 Bowling Green Township Board meeting. The single bid township-wide trash mandate contract signed by the Board of Trustees was not enacted until August of 2011. During my term of office, 06-09, the topic was never discussed. In the referenced video, I am clearly on the board, and the video could not contain any statement at all about any trash topic, let alone some kind of false statement or probable cause. Mr. Watkins' allegation number 2 is a fallacy. Regarding Watkins' allegation number 3, I find it curious how it is taken completely out of context. Mr. Watkins conveniently fails to mention his later public claims that the funds for paying volunteers' labor, after the fact, came out of the maintenance fund and not the park fund. The park committee was set up in the first place to oversee and manage projects such as the community building, park, and their maintenance. He also fails to note my follow-up editorial on the subject, clearly noting his stance. He is the one that labels this assertion as being improper. The 110511 editorial, he notes, did not label his actions as improper. It was simply my perception based on the official meeting minutes of the events. This being said, I looked at the supporting statements made here by Mr. Watkins. He claims the paying of volunteers' artwork labor had been discussed and documented in meeting minutes for 2 months prior to the action. This is a fallacy. The meeting minutes actually only support my editorial opinions. Official resolution, December 28, 2010, from official meeting minutes, after the project was done, quote, Trustee Watkins made a motion to pay the women painting the community building $300 plus expenses. Trustee Hupp seconded the motion. All in favor, end quote. A check number also dated December 28, 2010, number 3683 for $331.55 is shown on these same meeting minutes, proving the check had been cut prior to the meeting and before the motion and after the work had been done by the so-called volunteers. There indeed was no public input prior to paying these artist volunteers' labor from the public funds. After giving this testimony, the board allowed Mr. Watkins to speak again and then allowed me to speak. By unanimous decision on all 3 of these Watkins charges, the board decided there was no probable cause.
Can't take him to town?
There's a man on the street interview. What did you witness today?
A fallacy being straightened out.